on us today. And I see people are still coming in. We've reached starting time, so I'll slowly but surely will start the meeting. First of all, in welcoming all the participants, good morning, good afternoon, good evening to wherever you joined this meeting from. So it's great to welcome you all to this joint event of the Geneva Human Rights Platform here at the Geneva Academy and the Center for Human Rights and Global Justice of New York University School of Law. I would like to welcome our distinguished panelists, professors who have contributed to the new edition of this book on the United Nations and human rights that we'll be discussing today, or that's the starting point of our discussions today. I will present the speakers just in a minute. As you saw in the program, Professor Shetai was supposed to give some introductory remarks, but here we're at the downside of the online world. So actually, due to technical problems, he was not able yet to join us. So he sends his apologies. Over the last decades, the United Nations has set up a remarkable and multifaceted system of mechanisms for the protection and promotion of human rights and the monitoring of their implementation. Within the system, functions have shifted and evolved from the ECOSOC to the UN General Assembly, for example, or also with the rise of the United Nations Human Rights Council's importance. The United Nations treaty bodies have multiplied and their speed of governance adaptation has not kept pace with the increasing numbers of parties, of reports, and of individual complaints. Numerous reform and review efforts have taken place, including the ongoing 2020 review of the treaty body system or the upcoming 2021-26 review of the Human Rights Council. At the same time, the governance of the human rights system within the UN has dramatically increased, notably with the development of the Office of the UN High Commissioner for Human Rights. In this online event today, the contributors to the new edition of Philip Alston and Frédéric Mégret's book, The United Nations and Human Rights, will critically examine the functions, procedures, and performance of each of those major UN organs dealing with human rights. Panelists will share their views and insights regarding the interplay of the charter-based and treaty-based organs, the role of the UN General Assembly, the Human Rights Council, treaty bodies, and OHCHR, in how they individually and collectively engage in monitoring human rights implementation by UN member states. So just on a technical note for this online meeting, so we have asked the speakers to speak for about 7 minutes each to introduce both the chapter they have been authoring in the book, but also then going from that into the current challenges they see. We'll then come to an open discussion, questions by the audience, and I would like to ask you to use the chat function for this. So as we're in a webinar setting, you cannot interact directly, but you can send your questions by chat and also your requests to enable your microphone to speak directly. Please do make use of the chat function for that. Also, in case there is any technical problems. So as mentioned, yes, Professor Stein is not with us at the moment, so I will come directly to the speakers and present them to start today's panel discussion. And I would like to also go in the following order. I would start with Philip Alston, who's the co-editor of the book, and John Norton Pomeroy, Professor of Law at NYU School of Law. And I think, Philip, you have had roles in most of those mechanisms, actually, as OHCHR staff, as a treaty body expert, as a special rapporteur. If I'm not mistaken, the role that you did not have would be the one of diplomat in the council or the GA, but otherwise, you know all those things very well. We will then come to Rosa Freedman, Professor of Law, Conflict and Global Development, and Director of the Global Development Division at the University of Reading, and author of the Chapter 5 on the Council and Commission on Human Rights. Then next would be Suzanne Egan, Associate Professor at Sutherland School of Law of the University College Dublin, formerly also a member of the Irish Human Rights Commission. And with us here at the Academy, Suzanne was notably involved in the academic platform on treaty body review and led there the consultations in that project for Europe. She's author of the chapter on the coordination between treaty bodies. Next speaker then will be Andrew Clapham, Professor of International Law at the Graduate Institute of International and Development Studies, and also, I should say, former director of the Geneva Academy. He is author of the chapters, so we have two speakers in one, if I may say, authored the chapters on the General Assembly, but also on the Office of the High Commissioner for Human Rights. So as I mentioned, after those presentations initially, we'll then come to a question and answer session, and I'm looking forward to a lively exchange. And with this, Philip, I would like to give you the floor as the co-editor of the book, but also as the as our partner in holding this event today on behalf of New York University School of Law. So Philip, over to you, please.
Thanks, Felix. I'm very grateful to the Academy for having taken the initiative to organize this, and it's a great pleasure to be here with Rosa, Andrew, and Suzanne. I contributed the chapter on the Committee on Economic, Social and Cultural Rights, and co-authored the introduction with Fred. But I want to just confine my comments to the overall system, and then hopefully later on we can get more specific. Just one observation, it's a little late to be making this, but this second edition had a very long gestation period because we had initially begun thinking about it way back in the 1990s. And one of the consequences of that is that the much greater awareness today of the importance of diversity in authorship is dramatically absent from this volume. We have an almost entirely European set of authors. All of them are absolutely excellent, but I think it is a little awkward to reflect on the absence of more diverse views, and I regret that. But as I said, the ink was cast over 20 years ago. Anyway, I think what's interesting by way of overview is the comparison that the book begins with. This is a time of great generalized gloom and with attacks on the UN system coming from a diverse array of sources. And so it's useful to do a comparison with the situation almost 30 years ago, because that's when the first edition came out. And while 30 years may not be a particularly scientific time frame, it's probably as good as most others. It's fascinating to see how dramatically the system has grown and matured and even transformed. It hasn't just been more of the same, a gradual growth. Obviously, there have been a lot of normative developments. There have been new treaties on disabilities, on disappearances, the older persons draft now. In the area of soft law, we've seen some major developments in terms of the Indigenous Peoples Declaration, for example. But just as importantly, there's been a huge proliferation of soft law developments with just even special procedures themselves generating an astonishing number of guidelines and principles and so on, which may or may not be classified properly as soft law, but nonetheless have normative ambitions and aspirations, and make for a very productive array of sources to be considered when looking at almost any issue. Obviously, and Suzanne will talk more about this, the jurisprudential output of the different treaty bodies has been immense. If we look at what CEDAW has done on a whole range of issues, we look at the Disabilities Committee, we look at the Social Rights Committee, all of them have really changed our understanding of a lot of these key norms. And I think in important ways, if we look at the Human Rights Committee, most recently its general comment number 36 on the right to life, the way that's then being applied in the context of climate change, it's a radically changed landscape from 1992 when the first edition came out. Even ratifications, which we tend to be rather blasé about now, because of course there aren't too many left to be achieved, but the Torture Convention went from 73 in 1992 to 171 today. CEDAW from 123 to 189. So really getting closer to universal ratification on a wide scale. Lots of new areas that come out, LGBTI, obviously, more controversially in view of the Geneva Consensus, or whatever it was called last week, on women's rights and reproductive rights. There's been huge developments in terms of the jurisprudence surrounding reproductive rights and abortion, which one would not necessarily have expected back then. Climate change, new technologies, and so on. I think I would finish just by echoing one of the comments that was in the first edition, which is that the UN human rights system has not grown as a result of any architectural vision. No one sat down and said, so how should we design these different organs and how should they interact with one another? I made the comment in the first edition that in fact the system has grown like Topsy, to use that expression. Very uncoordinated, very unpredictable, very untidy and uneven. And despite all of the aspirations over the decades on the part of diplomats in particular to say, okay, we have to clean this up, we've got to tidy it up, we've got to get rid of the parts we don't like. What we see instead is great strength in polycentricity. So that where one body is lagging behind, another is well able to innovate and to keep the field moving forward. I think the special procedures, obviously I have a particular interest there, and because I served 2 different mandates, but I think that is a singularly vibrant group despite periodic attacks on it. And it has succeeded in bringing very significant levels of expertise into the overall system and ensuring that the system keeps up with new challenges in a way that the bureaucracy on its own might not be generally inclined to do. So overall, I would finish by saying that I think the picture that emerges from this new volume is much less gloomy than that which we read in the foreign policy journals, etc. I'll leave it at that.
Thank you very much, Philip, and thank you for putting us in perspective, because I think, as you say, a gloomy picture is around, and indeed bad news are the news that we read about. So it's very helpful actually to be put in perspective, to hear the numbers and to reflect on the development, which actually, as you say, might not always be going along with a big vision, but uncoordinated, but obviously uncoordinated also replying to the needs, replying to political developments. So if you allow me to first come maybe to the Human Rights Council as the prime political organ in that game. There was obviously a big reform and from the Commission to the Council. So Rosa, if you could enlighten us on what works, what needs further reform maybe also, and where you see that going. Please, over to you.
Thank you very much. Thank you for inviting me to participate in this event. It was a privilege and it was an honor to have written a chapter for Philip and Fred's book. And I hadn't realized quite how long the gestation period was for, but I was probably still in school when they first started speaking about it. It's a privilege also to speak on this panel of esteemed colleagues. And I was told that the topic for today is the sort of reform and review of the human rights mechanisms, which I think comes at a really interesting time for the Human Rights Council, because it was only a couple of years ago that the US, when it was still engaging with the Council, led attempts to reform the Council sort of from the inside. And yet we're only a year or so away, not even a year, a few months away from the General Assembly review of the body that will take place between 2021 and 2026. So it seems a good time to reflect on what reforms have been proposed in the past and what reforms might come from this review. And I don't have much time, so I'll only talk about a few points. The Human Rights Council is a political body. It's made up of member states. During the reform from the Commission to the Council, there were proposals for there to be all 193 UN member states sitting on the body, or for there to be a small number of independent experts, a little bit like the treaty bodies are. But neither of those were taken up. And instead, we have this proportionate geographic representation. Member states send diplomats rather than human rights experts. And because of that, because it's an intergovernmental body, it will by its nature be political. And because states by their very nature behave in political ways, there will be politicization. But the politicization that has been apparent from the beginning of the Council has really undermined a lot of its legitimacy and reputation, even if the work that it does is not always undermined by that politicization. And there are different types of politicization. There's pernicious politicization, which is when states will use the Council as a way of undermining human rights, a way of not just seeking to dilute them or to change them, but to change the very nature of them, or to threaten or challenge the system. There can also be positive politicization, where states will use the Council to try and provide technical support or assistance, or to provide early warning systems, but in a politicized way. That's the nature of diplomacy. And quite often when we criticize the Council for politicization, we don't also recognize the skillful ways that some countries use the Council, or that diplomats will use their platform to try and advance human rights. But if we're talking about reform and review, I often think what we're talking about is how do we strengthen and enhance. So I'm only going to focus on some of the areas that are challenges and that do need strengthening and enhancing. First of all, the Council's membership. It's always been a serious challenge. The soft membership criteria that we have very rarely result in grave abusers not being elected to the body. We also, because of the nature of how the seats are apportioned according to regional groups, means that there are some very strong political alliances, like the Organization of Islamic Cooperation, which use their weight to politicize the Council, to shift focus away from some of the crisis human rights situations in their allied countries, and ones that desperately require attention. And the membership also undermines the Council's reputation and legitimacy. When countries that are grave abusers are elected to the Human Rights Council, the media will report on it. And many people in the wider world, outside of the human rights world, don't understand the nature of the Council. So what they see are grave abusers being appointed to this UN main human rights body, and they question what the purpose of the body is. The second key challenge that has remained a deep source of shame for the Council since its creation is having Agenda Item 7. Having one standing agenda item on one country or one country situation and occupied territories alone makes a mockery of the whole reform process from Commission to Council, because the idea was to make sure that this was a body that was not so politicized, that it focused so much attention on one situation, that it took away attention from similar or worse situations elsewhere. In 2018, the US led attempts to reform membership, and this was particularly driven as a reaction to the DRC being elected to the Council in 2017. The US also pushed, this is under Haley, Ambassador Haley, to restructure the debates in order that there would only be one Agenda Item 7 debate every year rather than 3. They also pushed in these reforms for more egregious country situations and atrocities to be addressed, including Venezuela. For various reasons that you can read about online, those attempts were derailed, partly by member states, because the council president at the time said there was a need for consensus. And it appears that some member states from Europe put pressure onto OIC countries to oppose it. They were also derailed later at the General Assembly by NGOs who were concerned that opening up discussions on the council and particularly on the standing agenda might lead to some countries trying to remove Agenda Item 4. The derailing of those reform attempts means that membership remains a key issue. But it's also important to highlight that membership does not always prevent the council from taking action, particularly on countries like Venezuela, which it has done over the last year or two. But there are many other countries who are shielded by their allies, because the allies are more concerned with the politics of protecting neighboring or political alliances than with promoting and protecting human rights. So looking to the review that's coming up, the 2021 to 2026 review, the review is being done by the General Assembly because that is the parent body. The council, we must remember, is a subsidiary body of the General Assembly. And I think that's the first key issue that needs to be addressed in the review process. Why is there one pillar of the United Nations that still does not have its own main body, its own organ of the UN? If the Human Rights Council were to be a main body of the UN, it would enable human rights to receive the platform that it requires and deserves as one of the UN 3 pillars. It would better enable the Council to work with other UN bodies, particularly on early warning, but also on mainstreaming rights across the UN system, which are 2 key areas where the Council could do more if it was given the ability to. There's also a need for the Council to play a role, and probably a key role, in the Secretary General's prevention agenda. And this is discussed in depth by Universal Rights Group, if anyone wants to read up on it more. There's a need, as Philip mentioned, to think more about the Human Rights Council and special procedures mandate holders. While it's a separate system, it's part of the Human Rights Council. There are regular and concerted attempts to limit the independence and scope of those mandate holders and mandates. These are the crown jewels of the UN human rights system. And every time there are attacks on them or attempts to limit them, it's deeply concerning. Those attacks and attempts to limit them have been going on throughout the time of the system and as the system has developed. But it appears that it's come to a point in time where we could perhaps formalize some protections for them. There needs to be greater measures for follow-up and also for measuring implementation. These are crucial for ensuring that the Council's work has impact, and there are some ad hoc follow-up mechanisms, but again, they need to be formalized. But it's also crucial for being able to assess the impact of the Council's work. In terms of membership, there must be competitive slates. That's the only way that we're going to start to address membership challenges, that regions cannot put forward de facto closed slates anymore. And then I think more broadly, there are 3 issues that I think need to be raised within any review or reform discussions. The first is the role and relationship of the High Commissioner to the Council, because we see how the personality of the High Commissioner drives agendas. And within that, a discussion about the role and nature of the Office of the High Commissioner's work. Because on the one hand, OHCHR supports the Council and special procedures, but on the other hand, it has its own field and country work, and these often conflict. And we often see, particularly amongst individuals supporting special procedures mandate holders, that they prioritize the OHCHR's work in the field and are asking mandate holders to hold back in some of the things they place into their reports. There's a need to understand these relationships because the Secretariat plays these different roles, and yet these often don't come up within review discussions. We also need to discuss the attacks on country resolutions. There must be efforts to ensure that these country resolutions are protected and may continue. They are a key part of the Council's protection and promotion mandates, and also the mandate to respond to crisis situations. And the fact that they are being eroded and that there are calls for them to be removed must be addressed. Lastly, and related to that, when we're talking about reviews, we could look only at formal rules, or we could address difficult challenges, ones that may not have easy answers, but we shouldn't shy away from discussing. And this goes back to the politicization point. There are countries, as we know, from the beginning of the Council, who have used the Council as a way to try and undermine the concept of human rights, whether it's through trying to advance a development agenda instead of human rights, or whether it's through a proliferation of rights, whether it's through simply attacks on things like who are rights holders. On the one hand, we need the Council to be able to work on key emerging areas like climate, like technologies, as it is doing, but we also need to find ways to address China and Cuba and other countries who use their platform, use their seat at the Council to try and remove the legal protections that have been created through the human rights system. Thank you.
Thank you very much. Thank you, Rosa, and thank you for qualifying also the politicization, because indeed we all hear about politicization of the Council as a general negative thing very often, but I think it's very pertinent, as you put it, also showing the positive and the negative sides of it, and actually the very nature of that political organ. Let me turn now to a less political, more expert organ of the human rights system. Nevertheless, there are political dimensions to this, I think. And also we see it in the review efforts going on right now. Let me turn to Suzanne Egan to invite you, Suzanne, to speak about treaty bodies, about the review of the treaty bodies and where you would see them going in order to fulfill their role within this intricate system. Suzanne, over to you.
Thank you very much, Felix, and thanks very much for the invitation to participate in this event. Thanks very much also to Philip and Frédéric for inviting me to contribute to the book. Like Rosa, I would say it was a great privilege to take part in the drafting of this book. Unlike Rosa, I would have been well out of school, obviously, when the discussions first arose as to putting the second edition together. It's also it was a pleasure to participate in the academic platform, Felix, and I know that some of the proposals that were put forward there are currently up for discussion. So the chapter I wrote for the collection concerns, of course, the never-ending question, it seems, of reform of the treaty system. And it comes at the end of part 3 of the book, which is entirely devoted to the treaty bodies and which includes numerous chapters detailing and evaluating the many achievements and the challenges experienced by individual treaty bodies. So my task was to consider the challenges that have been encountered over the years in making the system as a whole more effective in practice. So I'll try to summarize the main points. And the first one to note, I suppose, is that although we find ourselves now truly in an extremely challenging situation vis-a-vis the operation of the treaty bodies because of the UN funding crisis and obviously also the COVID-19 pandemic, as everyone participating here today will know, the treaty system has been described as operating in crisis mode for decades, with grim warnings that it is on the brink of collapse due to the chronic under-resourcing of it, and the gamut of what have been described as institutional pathologies in the operation of the treaty body procedures. And yet it has continued to survive and continued, as Philip has mentioned, to contribute greatly to our understanding of key norms in the treaties. So the chapter I wrote outlines the nature and substance of various initiatives that have been taken by the UN over the years aimed at reforming the treaty system, or euphemistically speaking, strengthening the treaty body system. And these include the expert reports by Philip in the 1990s, which led to a number of incremental changes in subsequent years, including the simplified reporting procedure. the proposal for a unified standing treaty body put forward by former Commissioner Louise Arbour, which effectively bombed in terms of its reception by the states parties, the treaty body members, and indeed civil society groups, largely, of course, because of the threat which it was perceived to pose to diluting issues, specific issues, but also because of the manner in which it was packaged and marketed to the actors in the system. It was perceived largely as a very much a top-down exercise. Then through the chapter then looks at the strengthening process championed by Arbour's successor, Navi Pillay, which took a very different format, including advanced consultations with a wide range of stakeholders. And that, of course, ultimately led to the General Assembly Resolution 68-268, which is now being revisited by the General Assembly in the context of the 2020 review process. So the chapter makes a number of points about each of these reform initiatives, but the key point that is perhaps of most relevance to where we are today at the present moment, and which I thought I'd focus on, is its attempt to unpack or to understand precisely why efforts to reform the treaty body system have proved to be so challenging over time. And this is a point that I think was brought to the fore in the context of Pillay's consultative process. And it is that the treaty system consists at this stage of much more than the treaty bodies themselves, but rather it includes all the other actors that participate and engage with the treaty bodies in the performance of their functions. And also that the treaty system does not operate and can no longer be seen as operating in splendid isolation. It sits alongside a panoply of other human rights mechanisms, most notably the special procedures and the UPR. And therefore, in moving forward, it's absolutely vital that the relationship between the treaty bodies and these other mechanisms become central to proposals for reform, and specifically finding ways of finding synergies between them. So just to elaborate on the point that the treaty system has to be seen, I think, in a wider context as involving multiple actors and involving various internal and external dependencies. It's very clear when you look at all the reform proposals that each of the different actors have different ideas about what the primary objective of the treaty body procedures should be. From the very minimalist view of some states at one end of the spectrum, that the core objective of the treaty bodies should simply be to provide advice to states on implementing treaty body obligations, to the view held by NGOs at the other end of the spectrum, that the objective is to hold states accountable for failure to adhere to obligations. And these differences in perspective can radically and does radically affect views on the proper substance and scope of treaty body activities and the measures necessary to meaningfully reform the system as a whole. And following on from this then is the observation that I make in the chapter that in any process aimed at reforming of any system or any enterprise, while the views of each of the stakeholders have to be taken into account, their relative power or salience is also a relevant factor. In other words, whose views are going to matter most in tackling reform. And I think deciding on stakeholder power and salience isn't necessarily obvious in the treaty system. We can probably take it for granted that states are the primary stakeholders, but they're by no means a coherent grouping, and they're arranged along a spectrum of those that are generally positive about the functioning of the treaty body systems to others that are, of course, very reluctant and non-conformist. But they are actors with very strong veto possibilities for blocking change. And so if change that is mooted is perceived to be overly threatening, then the states will simply block it. And that is what happens with the Unified Standing Treaty Body Initiative. What about non-governmental organizations and national human rights institutions, for example? In days of old, when Philip was speaking about 30 years ago, their input would have been regarded as not so important to the treaty system. But time has seen a hugely significant change in the political context in which the treaty bodies operate. And with that, there has been a significant shift in the balance of power amongst the various different institutional actors. So NGO input, most would agree, is now a vitally important part of reporting procedures, to the point that NGOs now argue very forcefully that they should be regarded as essential partners in the system. Now, with the advent of UPR and in a context where NGOs increasingly have to allocate very scarce resources, they have to make intelligent choices about where they're going to direct their attention. And this has given them significant leverage vis-a-vis the treaty bodies themselves, but not necessarily the states parties. There are obviously a range of other actors too that are too numerous to go into here, but the point I'm making is that when we drill down into it, we see that there are multiple parties with a stake in the work of the treaty bodies and their outputs. They each have varying levels of participation and interest in the system, and each are sometimes aligned with each other, but sometimes very conflicting demands and expectations of the system. So we can easily deduce, therefore, that this has been a critical problem in driving change forward. Because the key players have not been aligned, they each have very different expectations as to what the system is designed for, what it should in fact be delivering. And this has implications each time a particular strategy is put forward for consideration or when attempts are made to negotiate change. So given that overall context, it's hardly surprising, therefore, that efforts to strengthen or reform the treaty system, while from an outsider's perspective might appear unreasonably modest, to people immersed in the system, they are by no means surprising, and that in actual fact, I think it's almost remarkable how some of the proposals that have come out of the various consultation processes, from Nave Pile's process right through to the present day, they seem almost by stealth to be gaining traction amongst the various stakeholders. These include the proposal, for example, for a master calendar, which was refined in the context of the academic platform launched by the Geneva Academy, and also other proposal and modalities put forward by NGOs. The idea of integrating, which include the idea of integrating reviews by the treaty bodies with reviews in the context of UPR. And to me, this approach certainly appears to hold advantages from all the stakeholders' perspectives in terms of increasing predictability and efficiency in the state reporting system. But it does carry with it resource implications, and also this controversial element from the state's point of view of review in the absence of a report. One encouraging development arising from the 2020 process, which has obviously happened since the chapter I wrote was written, is the observation made by the co-facilitators in their report to the General Assembly recently, that the consultations have demonstrated, and I quote, that the development of a fixed calendar is a desirable feature of any future format of the human rights treaty body system. And so the nature of a fixed calendar, the question of cost still has to be resolved. But I think if this can be gotten across the line, I would see that as real progress. The other suggestion that emerged during PLA's strengthening process, which at the time was sort of sidelined, I think, in her final report, but which I argue in the chapter has real potential for tackling the vacuum in a leadership structure, which is always necessary to drive any reform forward in a system. The suggestion to conceptualize the chairpersons of the treaty bodies as a sort of executive bureau. I think codifying the role of chairpersons has real potential for harmonizing working methods. And clearly we can see, again, from the chairperson's 2019 vision statement, that there has been some progress in terms of this grouping moving towards operating as a more cohesive unit. And this is a development that I think is clearly to be welcomed. And there are obvious incentives, I think, for the treaty bodies to get behind this effort as their fate is becoming increasingly uncertain in the current climate. And the final point then I'd like to make regarding the need to conceptualize the treaty system in a wider context is that while reform efforts have tended to focus constantly on the operation of the treaty procedures, or predominantly on the operation of the treaty procedures, there is really much potential for civil society, national human rights institutions, transnational networks to continue to focus on ways to enhance the treaty system and extract even greater value from it through a range of measures that could be taken at national level. Continued lobbying, for example, for more open and transparent nomination and election procedures, national reporting mechanisms, capacity building, critically analysing the most effective means for follow-up. Is it by pressurizing the treaty bodies to up their game in terms of follow-up, or perhaps systematising more follow-up into the UPR? So my chapter concludes, hopefully, on a positive note, that while there are no magic bullets for reforming the treaty system, it is by no means, in my view, a meaningless endeavour. And I finish with the comment that the continued dynamic, multifaceted effectiveness of the treaty system, when it is viewed as encompassing a wide variety of actors, a wide array of actors, in the face of all its moments of crisis, makes continued effort at improvement worthwhile. Thank you.
Thank you very much, Suzanne, and I'm looking forward also to come maybe in the discussion later on also on the implications that we are seeing now under the discussions with the COVID situation and what could be learned from that actually to move into the normal working methods of treaty bodies. There's discussions around that too. But let me come now to Andrew Clapham. So Andrew, as I said, you wrote the chapters on the General Assembly and on the Office of the High Commissioner for Human Rights. So actually on two entities that are the ones that can move change ahead. And we see that the discussions, well, as Rosa mentioned, of the Human Rights Council, the review is carried by the GA. And for the treaty bodies, even if some question the legitimacy, it's also carried by the GA. And the Office of the High Commissioner is always the big soft power behind that can make some changes happen. So I'm very much looking forward to hearing from you, your views. And you did tell us that you are teaching a course later on, so you will not stay all through the question and answer. So if you have picked some questions already from the chat, or if you want to anticipate some questions, and I think one would be definitely on the coherence and the connectivity of different areas of the human rights system and the wider UN system, maybe you can address those with a word already in your initial presentation now. So the floor is yours, Andrew.
Well, thank you, Felix, and thank you for having me on this panel. I think the second edition is a fantastic addition to the scholarship in this area. And as Philip has explained, and as the preface explained, a lot has indeed changed over the last 20 years. And he's mentioned some of the big institutional changes, the Human Rights Council, new treaties, and of course, all the normative output. But the advantage of this book sort of having been written over 20 years is that there's also been a chance to see how some of the bodies themselves have changed during that period. So not just new things that arrived, but how the organs themselves have changed. And one of the things I tried to focus on in my chapter, and maybe I'll talk to it a bit now, is how when we talk about these bodies, we look at the rules of procedure and the resolutions that come out and the structural things that Felix and Rosa have been talking about. But we tend not to remember that these bodies are actually made up of people. That the General Assembly, of course, is an assembly of member states, and we can talk about that as international relations scholars. But each one of those people sitting behind the little, nameplate that you see there is a human being, to put it sort of crudely. And my experience of sitting in the General Assembly was that a lot of the resolutions and big initiatives wouldn't have happened but for the sort of personal investment of one or two, or obviously more than that, but a few individuals. We can analyze the resolution that created the High Commissioner for Human Rights or the Indigenous Peoples Resolution, but actually there are one or two people who sit up all night and work on those texts and invest in it and convince their governments. It's not usually always that capital just tells a diplomat to do something. And I think going forward with the General Assembly, that's something worth thinking about. What sort of person goes to the third committee? And what could one expect them to do in terms of innovative improvements? And how much do they understand, Felix, if you want me to talk about coherence, how much do they understand about Geneva or treaty bodies and those other questions? So if one was to think about the third committee for a moment, which is where the human rights debate takes place, what I realized is that on average, a delegate will stay for 3 years and then they will move on to other work. So there's a sort of period when they actually get involved. And in those days, we actually used to meet in cafes and restaurants. There were even dances. There's a lot of physical interaction, or there used to be, and people form into groups that actually feel quite committed to texts, not texts for the sake of it, but ideas, whether it's about arbitrary disappearances or even a country resolution. And I think as we go virtual on some of these things, that's worth bearing in mind, that there's a risk of sort of disconnectedness with the extra connectivity, if you like. I realized after I'd done 7 General Assemblies at the third committee that there was nobody left in the room who had been there from the beginning. I mean, I was the last one who sort of knew how things worked, because new people would come in. And at that time, there were no NGOs either at the General Assembly, which I guess is something up for reform. As far as I know, there's still no provision for NGO participation. I used to sit next to Switzerland, the ICRC, Palestine, and the Holy See. and none of those really thought it was appropriate that amnesty should be associated with them. And so it's a very different atmosphere in Geneva, where you have diplomats who have been working at the Human Rights Council for years, and there's an esprit de corps, to use a Geneva expression, which means that things happen. And I think if one wanted to make the General Assembly into a dynamic place which is capable of protecting human rights, one has to think about some of the socialization that needs to go on there. And I do remember one or two instances when diplomats went beyond thinking so much about their text and actually felt physically moved by what had happened. And those were the moments when the General Assembly did react. I'm thinking in particular of a massacre in East Timor, which was shown as a video, and people felt that it was time that the General Assembly should do something. Now, in those days, the Human Rights Council didn't sit all year long, and the General Assembly was the only place one could take something like that. Now that the Human Rights Council could indeed have an emergency session on something, one does have to ask, what is it that the General Assembly could do that the Human Rights Council can't do when there's an emergency like that, or a country situation? And one of the points, I'm not sure how much I developed it in the chapter, but it's something that struck me again this week, is that when diplomats physically travel to a country, and it can be a group of 5 from representing the different regions, and then they come back and take up their diplomatic function in the body, they do actually start to understand the situation and start to take initiatives at the international level which help the country. And in my experience, I've seen this happen with Security Council missions where ambassadors physically go to the place. And from time to time, it's been mooted that ambassadors should go from the General Assembly or the Human Rights Council. It sounds a very simple thing, and it sounds an odd thing during COVID, but it's actually something that makes people understand what's the point of being at the General Assembly and passing all these resolutions. And usually some creativity can come out of that. So what other things could the General Assembly do in the future now that we have the Human Rights Council? Looking at the General Assembly over the last 20 years, one of the points at the beginning was that the General Assembly can do things when the Security Council is blocked. Now, in the past, when I first started writing the chapter, that related to things like the United States wanting to go to the General Assembly, ironically, to go around the Security Council, which had an arms embargo on Bosnia. So the idea that you use the universal level at the equivalent level of the primary organ of the UN, principal organ of the UN, to do something when the Security Council won't let you do it. What does that mean today? I think it's going to be less about trying to thwart an arms embargo, but I still think there's room to do things. And 2 recent initiatives have struck me. One related to Syria. When the Security Council refused to, or was vetoed from allowing the International Criminal Court to deal with Syria, you see a very interesting initiative at the General Assembly, which ends up with what's known in Geneva as the IIIM mechanism, which collects information about crimes committed in Syria for future prosecutions. And some of those prosecutions are now happening. Now, again, if you go back to the General Assembly as an organ dealing with human rights, one wouldn't have predicted that it would be capable of doing that. But that initiative was down to a few diplomats from a few countries being absolutely determined that the UN would not just stand by because of the veto of 2 countries at the Security Council and not talk about crimes in Syria. And there's a similar initiative with regards to Myanmar, and I could see in the future, given the right diplomats, the General Assembly taking on more of a role where the Security Council's action is inadequate, or indeed where the Human Rights Council, because of the sort of membership problems that Rosa Freedman is talking about, is unable to deal with the situation because of a power blocking the Council from acting. So I think there's definitely room for the General Assembly, not just as the normative body and not just as a parent body to the Human Rights Council, but something in New York that can provide a way forward when the Security Council is blocked, or indeed when the Human Rights Council is blocked. Maybe in the last few minutes, I should talk a little bit about the High Commissioner for Human Rights. Again, it's not so much about analyzing the institution and what it can do, But we should probably start to think a bit about the personality of the High Commissioner and the sort of tone and entrees that that leads to. So each of the High Commissioners have been able to make their own progress, partly based on their background and partly based on their approach. And some will have chosen to do things differently from the predecessor precisely because the predecessor did it like that. And that might be okay. But what it has done is it has given the office, as Rosa has suggested, its own capacity, not just to carry out research and support entities, but to have its own opinions on things as an office, which the High Commissioner can then head up. And I think 20 years ago, if you'd told me, that the High Commissioner's office would have legal opinions on things and would file amicus briefs in the Supreme Court of the United States over Guantanamo, I would have said, no, we're not there yet. But again, looking at it over 20 years, when I first started the chapter on the High Commissioner, I think there were the budget, the PBI said there would be 4 people in the office of the High Commissioner for Human Rights, and it would have a budget of 1.5 million. And now, as you know, it's 1,000 people and 200 million. Now, I appreciate that it's absorbed the Center for Human Rights, but it's not that simple. The fact is that the office has a huge impact. It can impact even on treaty body work by providing its own opinions. It can not just assist a special rapporteur, but help in the intellectual work of deciding what the mandate and where the mandate should take it. It can have positions on transitional justice and so on, even advising the Secretary General, which again, if you'd asked me 20 years ago, would the Secretary General want to know what the High Commissioner's office opinion is on a point of law, it would have, you would have been laughed at. So it's huge progress. And perhaps just to sort of finish on this idea, when the concept of the High Commissioner was being floated around in 1992 and 1993, I don't know if Philip can remember this metaphor, but one of the issues, and again, it arose from this massacre in East Timor, was that, well, the Secretary General is not going to do anything, the Security Council is not going to do anything, the Commission's not going to do anything, the GA is not going to do anything. We should have somebody who opens the newspaper and can issue a statement at least and investigate, and that should be the High Commissioner. And the image of opening the newspaper and putting out a statement, even if the member states don't give you the mandate to do it on the day, I think is an important one. And I was thinking about events this week with the High Commissioner issuing a statement on Nigeria. Again, sort of inconceivable 20 years ago that an Undersecretary General would just issue a full statement like that on a situation in a country without a special mandate. So I think there's a lot to celebrate. I think there's real progress. I think the reforms that Suzanne and Rosa were talking about are extremely important. And I look forward to reading about them in the 3rd edition, Philip. Thank you.
Thank you. Thank you very much, Andrew, for that overview of both the General Assembly and the Office of the High Commissioner and those functions. So I would like to open the floor now to questions and comments. There have been some questions and comments also coming in by the chat. I see also already one participant raising her hand, so I will call on her very soon. Andrew, I know, as I said, that you'll be needing to leave us soon. So if I could also ask questions to Andrew, maybe put first. And also, Andrew, I might have one, as you spoke about the importance of people and about the 3rd committee. I was just wondering at that moment what the link between this person and the one in the 5th committee might be, because it seems right now that the development in the 3rd might be quite positive, while the 5th doesn't follow suit. So if I don't know how many minutes you actually do have before you have to leave us, Andrew. Can I take maybe Felice to ask a question? Will you still be able to stay for some minutes? So then Felice, I'll actually allow you in to talk. So you should be able, if you unmute your microphone, to put forward your question or comment. Felice Gaia, please. Okay, I do not hear you. So I have, I'll jump now to, I'll come back to you, Felice, maybe later. So I see another person, Ian Byrne, if I read the name correctly, please. Floor is yours. What's your question? Okay, your microphone is on, but we cannot hear you. You can also write it in the chat if you wish.
Maybe Felix, just while they're trying to get their microphones to work, I'll maybe add that Felice Gear is precisely one of the people I was alluding to in 1993, who did sit around drafting and working very hard on the different paragraphs and lobbying in all the right places.
Thank you. And Ian, I don't hear you yet, so I don't know. Andrew, would you like to give a word also? Yes, then that's a question on the World Court. So that goes more to Suzanne. I don't know, Andrew, if you want to comment on that one also. What's the thinking on a World Court, given the pressures treaty bodies are under? So that would be a question, and maybe also my point on the Fifth Committee. I don't know, Andrew, if we can still ask you some comments as long as you're with us in this meeting.
Okay, on the Fifth Committee, I mean, yes, obviously there's no point in us talking about a fantastic human rights program if the money is blocked in the Fifth Committee. I think non-governmental organizations would be well advised to follow the Fifth Committee, to lobby the Fifth Committee, and to lobby capitals to make sure that their human rights policy is in line with the way in which they're holding the purse strings. While we're on the subject, if one wants to really get effective action on some of these projects through the budget, it's not enough to lobby the Fifth Committee. You have to lobby something called ACABQ, which is a rather specialist and obscure body, but they are ultimately the people who decide where the budgets go. And both ACABQ and the Fifth Committee, for your information, for some reason which I never really understood, tend to meet all through the night. So if you're a lobbyist, you need a strong constitution to engage in that. But certainly that's where you need to take action. I see that others are ready to discuss the World Court, but I will leave that then to them.
Thank you. Thank you very much, Andrew. And I hope you can stay a little. So if some questions come in, otherwise, let me thank you already for your contribution. So I would like to, well, take the questions that are coming in. And as I said, there was a question actually on again, connectivity. It was a question relating to the combination or synergies, potential synergies on reporting under treaty bodies and in other parts of the UN system. So the example made was the Paris Agreement and actually climate negotiation related reporting, whether states with little capacity could see any areas of synergy in the reporting. I don't know, Suzanne, if that goes also a little bit into what you said when you were speaking earlier about UPR and treaty bodies and reporting. And then there's this point on the World Court that I would also first of all give to you, but then also come to Rosa, who also said she would voluntarily contribute to that. So maybe Suzanne, first of all to you, if I may.
And I'll perhaps comment on the question about the World Court. I suppose the world is divided into optimists and pessimists, and on this particular issue, I think that the politics of pragmatism have to prevail. In my own view, many of the suggestions around the World Court come from the legal branch of things, but maybe I'd be interested to hear what Rosa thinks. I think that judging by the reaction to the Unified Standing Treaty Body proposal, there was really absolutely no appetite for a World Court of Human Rights. So the current context that we find ourselves in, I would be someone who I suppose would be keener to see more pragmatic proposals being pushed than that particular one. And maybe that's displaying a lack of vision. I don't know, but that would certainly be my view on that. As to the comment in relation to synergies between, I think it's the reporting under the Paris Agreement. Sorry, I'm losing it in the chat. Does the opportunity for greater synergy between the two frameworks, the Paris Climate Agreement and the treaty body system? Of course, I think that is one of the things, as I mentioned in my earlier comments, that the more synergies that can be exploited between systems, internally within the treaty system and externally, the better. So the suggestion here being made by Jeffrey that the information compiled under the climate change under the Paris Agreement could also be used to fulfill UN reporting obligations. Absolutely, I think there would be a very clear linkage there.
Thank you very much. And Rosa, if you would like to continue on the World Court question.
I agree with what Suzanne said, and I think that from an idealist perspective, it was a very nice article. I think it was Manfred Nowak and Martin Scheinin wrote this very nice article about the need for a world court, and that seems to have been picked up and run with for many, many years. But it's very difficult to think in this day and age with the fragmentation of concepts of human rights around what human rights might apply, let alone around international relations. And the politics of human rights, how such a world court could ever get up and running. And I think during the 90s, in this great hope of a time of interrelated and indivisible human rights, and that everyone was going to come together around this idealism, that the idea of a world court sounded good. I mean, you'd have to hammer out what that court looked like. But if we can't even get the UN human rights main body to function in a way where there's some form of agreement about protection and promotion, how could we possibly hope to have a world court on it?
Thank you. And if I may pick up another question from the chat, and you all are professors, you all are engaging in human rights education, but the question was going to a population that might not always be in your classes, about the larger public and about political leaders. Well, we hope those come through your universities, but some do not. So actually, any views? And I think there also, Philip, I think lately you were also in another forum at the Right On chat discussing on how to better communicate human rights and how to get away maybe from that gloomy picture, because if I may pick up also on what you all said, especially I think Philip and also Andrew, in terms of the development and the positive developments in the system, but then the negative image of its delivery in the general public. So would you have any comments on that? Well, it was a question or a comment actually, how to educate the political leaders and get more of a positive view of human rights. And then later I would like to come also to the COVID related questions, where two of them are also popping up in the chat. I don't know, Philip, if I can ask you to comment maybe on that way of communicating human rights.
Maybe Andrew should go first, Felix, if he's pressed for time.
Of course, please, Andrew.
Sorry, I was just about to leave. I see there are a lot of questions. You want, the main point was how to better communicate the general ideas about human rights, rather than considering it as a question of all these interlocking bodies.
Yes, I think so, yes. Mm-hmm.
I think as professors, and Philip is very good at this, so it's not a criticism of him or Rosa or Suzanne, of getting out there and explaining what human rights really are in the normal media, I mean, on radio and television and the social media, because most of the time there's a huge misunderstanding about what human rights is or what a human rights lawyer does. In the UK, it's particularly a vicious atmosphere at the moment, but one can find it in other countries. And I think it behoves us as human rights professors to do as many public events as we can to dispel a lot of the nonsense that's talked about human rights, and not to feel that we have to be defensive and that there's something wrong with human rights. But it's a very attractive idea if explained properly, and it doesn't have to be colonial or imposed by the West. That's something which is often put around precisely not to live up to the sort of behavior that respects human dignity. So I think the Academy also obviously has the Geneva Academy has a role here as well, that we can get a bit lost in the weeds of treaty body reform and the meaning of Security Council resolutions, and forget that when people are asked in Egypt or in Somalia what it is that they want, they talk about justice and rights and human rights in a way which is very meaningful. And I don't think we should be frightened about talking about human rights.
Thank you very much. Thank you, Andrew, for that. And Philip, would you like to go next? And then we'll read out also next the question that came in now from Felice by chat. But first of all, to you.
Yeah, I think there are different different currents that we are trying to cope with, and they may not be flowing all in the same direction. So I am much less pessimistic about the likely consequences of the assaults that are being launched on the system, whether by Presidents Duterte, Bolsonaro, Trump, Erdogan, Modi, and others. I think that the human rights system is always going to be subject to attacks and assaults from various directions. But what is so far reassuring is that it hasn't collapsed. There are always countervailing forces. There are governments, countries that feel that the system is in their interests. And those constellations will change. And I don't think that there is a day where the whole system is going to collapse. The other side of the debate, though, is that the recent re-examination has led most people, or many people within the human rights community, to conclude that we haven't been doing things as effectively as we should have. I think we do need, as Andrew said, to be getting out much more. I think we need to be making our case, not assuming that it's self-evident. We need to be using not just the traditional media, but social media. You know, it's true that teenagers mainly communicate through Instagram and Snapchat and would never read a newspaper. The human rights system has to adjust to these new forms of communication, but we also have to package issues in ways that make them more attractive. We have to be able to persuade the broader community that human rights are not, as the British tabloids would say, only for the drug dealers and the rapists and the murderers, but they are for everyone. And particularly when governments are so oblivious to the interests of the masses these days in so many countries, there's a very big opportunity, I think, for the human rights community to be trying to sell a product that has much greater appeal than was the case in the past.
Thank you very much, Philip, for that. And let me read out the question sent by Félix Gaer. So it's two questions, actually, to see who would like to come in on those. So the first question, what the panelists think about the proposal to make the OHCHR a truly separate and independent agency of the UN. Would it get rid of the governmental interference and weakening efforts? And would it benefit the development of human rights law and its credibility? Or would it isolate and weaken the UN on human rights? And then the second question is what people do think about the impact. It's also related to OHCHR, what people think about the impact of the ASG, the Assistant Secretary General for Human Rights in New York, and moving so many staff to New York. So what's the impact of that creation and moving of staff to New York? So I don't know who would like to come in on that. I think Andrew has needed to leave now to teach his class. So I'll put it also to the others who volunteers to comment on this.
Well, I guess, first of all, thanks to Felice, who is a giant in the human rights field, has contributed immensely over more years than she would like to admit. These questions have a funny resonance for someone like myself who's been around also for so long, because of course they were questions that we were debating long ago, but they now have a whole new salience. I think it's very hard to predict what it would mean to turn OHCHR into an independent body, but I guess that would mean that it would then have a governing board, which in some ways would be different from the Human Rights Council. I'm not sure that that disconnect would necessarily be a good thing. I think an independent body might be under more pressure to be more UNDP-like. In other words, much more focused on diplomacy, on doing what governments on what will please governments, and not be forced to be confronting and reacting to ongoing violations and so on. So I'd be wary, I think, of the independent agency move. In terms of New York and Geneva, I think that the central focus remains basically on Geneva, but clearly the Office of the High Commissioner does need to be more effective in New York to have a bigger staff and a bigger impact on the mainstream events going there. But again, I think I would regret it if it meant that the office were one day to be moved in its entirety back to New York. I think that would have a very negative impact.
Thank you for those comments, and I'm trying to monitor the very active chat. So I would also obviously invite the speakers, if you pick up a question you want to speak to, just to do so without me repeating it. But now I'd like to, so I see Rosa Freedman would like to speak, and there is a question aside of the education question also again on the Human Rights Council performance under COVID, if you might want to address that too. And Suzanne also already mentioned she would also say something on human rights education. And again, the COVID point, I would bring it to you as well in terms of the treaty bodies that, for example, have not been able to engage fully yet in state reviews, and it's questionable how they will be. And there is a question also linked in a way to that, saying that other mechanisms do all their work desk-based and are quite effective. So shouldn't the UN save money and do away with the presential meetings of treaty bodies? So we have quite some strong questions, strong comments to get back to. So first of all, over to you, Rosa, please.
I just a question had just come in which picks up on what Philip was saying. Saying should the question about OHCHR really be asked about whether treaty bodies and special procedures are separated from them to make them independent? And I think this is really crucial. There's just not enough capacity in OHCHR to provide support to mandate holders or to provide the kind of research support that treaty bodies might need. So on the one hand, you have this really strong support in terms of technical issues, in terms of being able to logistics, things like that. But then there's been this pushback from OHCHR against people, mandate holders, bringing their own research assistants with them, or using the expertise that they have around them in their institutions or organizations. And there really are. I mean, there's so many examples of where new mandate holders have felt under pressure from OHCHR staff, or where the support given just doesn't have the expertise. And it might be time to say that these systems are now too big to be able to be supported by a part of the Secretariat that has a conflict of interest. But in order to address that, we have to ask those questions and we have to be honest about it. And there is so much protection of, people want to protect their piece of the pie, that we're not having the needed conversations about what is true independence. And when, and it's not all of them, but when some members of staff are trying to tell mandate holders what they can and can't write in their reports, then it is completely undermining the independence of those mandate holders.
Thank you very much. And we might have someone who has experience with that kind of undermining. But first of all, now let me come to Suzanne, please, Suzanne. And if I may add to the list that you have been yourself already establishing, I see there's also a question coming up on the new treaty process towards transnational corporations and whether torpedoing negotiations of a new instrument is a new development. I think it's not. It's an established political practice, but it also refers in a way to treaty bodies, or say to treaties. So I don't know if you would like to address that as well, but there was plenty of other questions. So I let you take the pick for we have 15 minutes remaining for all the meetings. I'm sure we cannot comment on everything. So do your prioritization also. And please, over to you, Suzanne.
Okay, thank you. I haven't had a chance to read the question on treaty, on the TNC, so I'll perhaps read that, come back to it. The one I was going to come into, the two questions I was going to come back in on was the issue of human rights and education, which is something that I do actually have a bit of a very strong interest in, and it's the fact that I think this is a much neglected area actually of human rights scholarship in general, and also neglected area perhaps in the work and outputs of many human rights organizations, because of course the right to education in many of the treaties, the International Covenant on Economic, Social and Cultural Rights, the CRC, all specify that the actual right to education should be aimed in particular at enhancing human dignity and respect for fundamental human rights and freedoms. And yet in our school systems, we don't actually have very often much attention focused on human rights and fundamental freedoms. So even though I totally agree that we need to step up our efforts, people need to step up their efforts in terms of communicating the message of human rights to the adult community, I think it actually starts sooner than that, and it starts with very much with young people in schools, and that would include not just education in relation to the substantive human rights that are out there, but also the ways in which human rights can be accessed through procedures, and in particular a lot more familiarity about the ways in which young people can act on their rights outside the national legal system. I think that's a very, very important focus of attention. I noticed Bryce Dixon, who I know well, has asked a question, and you've raised it a couple of times, Felix, as well, about the operation of the treaty bodies in the context of COVID-19. And he's asking the question, how come the Council of Europe treaty monitoring bodies can operate at least as effectively as UN treaty bodies by relying only on documents and not on face-to-face meetings? Would dispensing with or reducing such meetings not save the UN a lot of money? And I suppose my answer to that is that the COVID-19 crisis is forcing, I suppose, the treaty bodies as well as other institutional actors to really reinvent ways in which they do actually operate. And undoubtedly, there is scope for using digital technologies for many of the functions that they have, and in particular the individual communications procedures, which of course largely take place behind closed doors in any case, in which we understand the treaty bodies are using technology for that purpose. But when it comes to the treaty body reporting procedures, while I do think there is obviously scope to move forward, and of necessity, because we know that state reporting procedures have come to a halt as a result of COVID-19. That has to move forward. Ways have to be found for the treaty systems, as much as other organizations, to adapt to the current climate. But there is a need, I think, to be very careful in that respect, in terms of inclusivity, accessibility, and transparency in relation to those procedures. So the Council of Europe obviously is a better resourced body for coming up with ways to deal with some of the glitches and problems. But I think that there is definitely scope, and moving forward in terms of online platforms is something that is absolutely a must-see development in terms of the treaty bodies going forward.
Thank you very much, and we have 10 minutes left, so we will have another opportunity to come back to each of you if there is any other question you want to pick on, and also for your concluding remarks. Philip, maybe over to you about the independence of special rapporteurs from OHCHR also, and then I think there was also, well, again, the COVID-related questions on the performance of the mechanisms under COVID, and also, well, you've been a long-standing member of the committee. You've been writing on the CESC committee, which, as I understand now, is moving into considering how to review states actually online. So maybe you'd also have some views on how such practice could evolve, be it in the crisis of COVID or be it in the what was it said before, the ongoing crisis mode under which treaty bodies operate, and you yourself in your reports have been mentioning that. So what is the potential of the digital shift there?
I would very quickly, I'd agree with Suzanne in terms of the pandemic, the unavoidable consequences of the pandemic having pointed us in the direction of giving much more serious consideration to technological ways of communicating and interacting and doing some of the work of the treaty bodies. By the same token, I'd caution against Bryce's analogy being taken too far. I think he's talking specifically about the Committee on the Social Charter, the European Social Charter. I think that's a very particular committee, the sort of approach that it adopts, the way it works. I think it needs to be seen as one part of a broader ecosystem within the Council of Europe, where you've got the Human Rights Commissioner and various other bodies that do get out. You've got a lot of bodies that do bring people in. So the Social Charter Committee is not necessarily representative. And I think the UN treaty bodies would lose a huge amount if they weren't able to perform this forum convening function that brings people together, that enables interaction. It really is just different at the end of the day. But it's certainly true that there's a huge amount of inefficiency in the way things are done at present, and there needs to be more creativity. Sadly, the question is, where will that come from? The office has not been very good at coming up with creative suggestions. It's usually driven by let's cut costs and so on. States obviously are going to be motivated by that, and I think the broader community needs to start thinking much more creatively about these issues. Independence of mandate holders. I think that, again, the system as a whole works pretty well. One could identify a number of mandate holders who have done extraordinary work in recent years in their respective areas, and they've managed to mobilize the additional resources needed, and they've managed to master the techniques that are required. I think there will always be tensions in the relationship with the office. I have to say that in the last couple of years, I have seen the office becoming quite paranoid, might be too strong a word, but much too focused on the potential of some negative response by states, and instituting a number of rules which have no foundation in past practice and which are not explained, but which are designed to restrain the freedom of mandate holders to work effectively. And I think that's really problematic, but that needs to be sorted out internally rather than leading to major changes in structures. The other issue that I'd comment on just very briefly is that I think I'm extremely concerned about what's going on in terms of business and human rights. I think we are seeing a car crash in progress, and I think that's going to be in no one's interests. We have the example of the Migrant Workers Convention, where a similar dynamic occurred many years ago, and it's been deeply problematic. The issue of corporate human rights obligations, not just responsibilities, is so central these days that we have to be looking at more creative ways forward and not just simply pushing ahead with a treaty that is by definition going to be resisted by a great many states for entirely selfish and self-motivated reasons. But that won't stop it from undermining the broader system. So we really need more creative thinking there.
Thank you very much. If I can come to our last round of comments, because we're getting to the close of this meeting. So If I could call first maybe on Rosa, then Susan, you, and give you a last word then to Philip to close the meeting. So Rosa, for you to address those different questions out there, and more questions pouring in by the minute, including one on actually the recognition by Philip in the very beginning of the panel, or the authors reflecting given geographic background and what to do about more diversity, but many other questions too. So take your pick, and over to you, Rosa.
Thank you. I think that's an interesting question that's come in, and I think we do need to recognize how much more diverse mandate holders have become, treaty body experts have become, and the sort of practitioners within the UN system. And I think we all need to make efforts, both in terms of our own academic institutions and who we write with and who we collaborate with, to make sure that that extends out into the academic expertise on international human rights law. But I think that's always the case, that the academic institutions and the writers catch up with the progress that's going on in regular society or here within the practitioners in the field. And I think it's something that we are increasingly, every one of us, more aware of and taking steps to address. But I think Philip was absolutely right, and the question asker is absolutely right, that we need to continue to ask these questions and address them and not shy away from them. In terms of the questions around COVID and about what the Human Rights Council can do in terms of what's going to happen next, the impacts of COVID, I would actually turn the question on itself and say, what's the impact of COVID on the Human Rights Council? We're seeing the impact of COVID and moving to online deeply in terms of diplomatic circles, because so much of diplomacy happens in the margins. So much of change happens around having coffee together, having a conversation together, seeing people. And so much of diplomacy cannot happen online because people are scared of it being recorded. People are scared to give background information. People are scared to talk freely and frankly about things that they wouldn't want their capital to hear. So there are deep concerns about the impact of COVID, or indeed about any epidemic or pandemic, whether it's global or it's local, right? That's what human rights institutions are there to address. That's what Philip's been doing in his mandate for how many years. That's our concern, where there's Ebola or cholera or anything else. But my other concern beyond the human rights violations, and that I don't think anyone can answer yet, is how much will human rights, the development of it, the implementation of it, the seeking to protect and promote it, be impacted by people meeting in this way?
Thank you very much, and over to you, Suzanne, please.
I don't think I have too much more to add to what I've already said. I do think in terms of the COVID-19 thing, I think it is particularly concerning that there has been such a halt in state reporting reviews. I mean, one perspective I have read is that it has given the treaty bodies an opportunity to catch up on the individual communications, and to a large extent, if you look at the Secretary General's last report, the increase in individual communications is now really a serious, significant problem, with about 80% increase since the last year. So there is profit, I suppose, in using the time to catch up with them. But the longer we go on without state reviews, the worse things get. So I do think that creative solutions, but I would completely endorse the position that we don't want to see a move towards creative solutions suddenly closing off the opportunity for face-to-face meetings, which do add so much to the treaty body system. And on the need for greater diversity, obviously, in human rights expertise and profiling of people. Of course, I agree with that, and I agree with Rosa. We need to do it in lots and lots of different ways, including, for example, greater diversity on our reading list and who we offer students to read when they're reading about human rights issues. Thank you.
Thank you very much, Susan. And as I said, Philip, for the closing, over to you.
Well, Felix, first of all, to thank you very much for having taken the initiative to set up this discussion. It's been very rewarding and a real pleasure to be on the panel with my fellow authors. I think it's a good note to end on, the issue of greater diversity. Again, you know, it's a glass half full, half empty, because it's useful to recall, I think the first ever special rapporteur, the first ever female special rapporteur was 1996, was Radhika Kumaraswamy. So, you know, 24 years ago, women were not up to dealing with issues like killings or torture or anything. These were too serious to be left to them. And I think we now have to start, not that we've achieved gender parity, but we now have to start making the move to much greater diversity in terms of the experts and so on who dominate the discussion. And I'm acutely aware of that as the classic elderly white male dinosaur from a Western country. But hopefully that change will be promoted. There's also a question on the board about the importance of poverty-related issues, and I'm not just coming out of my mandate, but I genuinely believe that we need to be focusing on the dimensions of poverty in relation to all of the human rights that we deal with. It's not a separate issue. If you're focused on violence against women or on torture or whatever, poor women are the ones who are going to be hit the most in every conceivable way. And so not factoring poverty into whatever you're doing is really going to limit hugely the effectiveness of the work that's being done. It's not just a question of going back to the old mantras about indivisibility of rights and so on. We need to expand our way of understanding even the really core issues. But thanks again to everyone. It's been a very good discussion.
Thank you very much, Philip. Thank you, and thank you to NYU for the partnership in this event. Thank you to all my panelists. It's been great to have your interventions and the discussion we just had right now. I would also like to thank all the participants for having been with us, and please do subscribe to our newsletters to be informed about upcoming events. Also, just to say, and I see people commenting on that on the chat too, again, on the great book and the great new edition that you did. And to mention that it's out also on paperback and as an ebook, so actually also more accessible to students than just the hardcover. So thank you all for this excellent discussions, and I think we do all want to see the UN continue to spearhead the development of human rights, but we surely should also harness and strengthen the potential of the national systems and its implementation. And I think there are those synergies that were addressed in various ways between the national and the international, between different international mechanisms. Is surely something we'll be continuing to focus on. Thank you all. Thanks for your interest and attention, and have a good rest of the day, evening, wherever you are. Thank you very much. And
thank you,
goodbye.
Felix. Thank you.
Thank you.